Good morning, afternoon, evening, whenever you're watching this, overnight, while you're sleeping. Not legal advice. Please like, please subscribe, please share, please comment, please share with your friends, your enemies, and your politicians, and your animals, of course. Say hello to your pets. Hello, doggies. Today I'm going to talk about Curt Kramer and the SEC and the notice of the action that was filed by the SEC yesterday. And before I get into that, of course, I wanted to address three quick topics. What did the executioner say to the death row inmate when his execution was expedited? Have I got news for you? Did you see that documentary on the death penalty last night? Tired concept, but great execution. And last but not least, what happened after the US imposed the death penalty for banking related crypto fraud? Bankmen fried. Anyway, moving forward, dealing with the SEC's actions. The SEC filed an action yesterday, or at least announced the filing of the action yesterday. Don't know if it's been served on the other side. In other words, provided to the other side, because it named at least four defendants: Curt Kramer, Geneva Roth, and I'm shortening the names, 1800 Diagonal, and Power Up, all names owned and controlled by Curt Kramer. By the way, any guy named Curt who doesn't spell it with a K, I have a problem with to start off with. But the SEC filed an action. I don't know if it's been served, but it will be served, and then it's a civil action as opposed to a criminal action. Although that could come down the road too, and hopefully will, and hopefully that will encourage others to stop doing this kind of conduct. But as of now, it was a civil action filed in court. The defendants, once they are served, will have an opportunity to respond. That's usually 30 days after they're served. They probably, unless there's some deal, they probably will aggressively respond. And I think it's in federal court. If it's in federal court, they'll file a motion to dismiss challenging the complaint, and that's how it will go. And of course, we'll keep you apprised how the actual litigation goes. But it's interesting that that the SEC has gone after them, and I'm sure Alpine, who we all know, is sweaty because of this, because it certainly could happen to Alpine, an action like this, even though there's currently, as I've mentioned multiple times, ongoing actions versus Alpine, which I'll quickly summarize. Appeal in DC regarding an expedited expulsion. That appeal is pending. It's been briefed, where we're just waiting for the decision. And then there's the expulsion that happened from DTCC, NSCC through Utah after various legal proceedings that was issued on or about April 25th. That's out for review now, I think, with the SEC, and then probably will go up to the Court of Appeal. Which one will win? Which one will work faster? How Alpine will be expelled? When will that occur? It's in process. And another appellate result against them from the one from DC will make it one step closer. So we're all hoping for that. And after this complaint was filed by the SEC yesterday, I'm sure Alpine, John Hurry, etc., are sweaty. So the SEC sued against Kramer and his entities. And recall that Kramer, or one of his entities, was a lender to GTII, apparently paid back by management of GTII, but we don't know the impact of whatever misconduct that the entities controlled by Kramer had on GTII to this point in time, because Kramer undertook his business in multiple names with multiple entities. So, as you will see, because I'll reference some of them, it could be one day, it could be Geneva Capital, Tuesday could be Frank. So we don't know until we have the full picture if, in fact, GTII has been further infected by Kramer. But notwithstanding that, the fact they had a prior interest, the fact that we know there's a concentrated short position, or was or at least appears to be, it would suggest that Alpine would have some concerns. So, but going back to the SEC action against Curt Kramer, it's for being an unregistered securities dealer. And he was obviously, the issue was that they were soliciting convertible notes. So they were actually calling up small microcap companies, offering to loan money, soliciting convertible notes, telling them how great it was, etc. During a 5-year period, so this is from January 2018 through March 2023, they lent out to microcaps approximately $135 million. And that involved 350 microcaps approximately, and 2,000 individual transactions. They got back from lending that money, they got back 66 million in cash plus 90 million of stock, but at a discount, somewhere on the order of 25 to 35%, sometimes more, which generated an extra 60 million in profit that we know of. And that was, again, it was just between 2018 through March of 2023. And that's just through the entities that the SEC looked at. Doesn't include, I'm sure, all the entities, brothers, sisters, aunts, associates, whatever. You know, you have to be realistic that if you find some misconduct, especially if the person's a recidivist, tough word to say, has repeated misconduct in the past, it's unlikely that those are the only times they've completed that misconduct, so that they're more likely to have gotten away with things in the past. So if someone like Curt Kramer, with a C, had been caught 3 times, probably had done it dozens of times and got away with it, at least. The basic allegations are that, besides the selling of the shares, but that Kramer controlled all the entities, that he signed off on all the documents, that he was basically running the show. And the complaint in its total, and it's a reason for my jokes, by the way, seeks a permanent injunction, basically a death penalty, against Kramer and the entities involved, although we have to be sure that he doesn't go infect other entities. Disgorgement of profits, so whatever profits they got, to return them. Civil penalties, and cancellation of any conversion rights. So this is not about changing religions, just means to the extent they have had ongoing contracts. Could that affect GTII? Perhaps. We don't know about that. Could be in a different name. But to the extent that there's ongoing contracts, that those contracts and the right for Kramer and his entities to make the loans and then convert those loans into discounted shares. And what they did with those shares is they would get discounted shares. They would then, and they created upwards of, I think it said 90 billion with a B shares, get them at a discount, sell them into the market, make a bunch of money, depress the stock price, and dilute the shares. That was the impact. So they profited, shareholders would not, company would pay out exorbitant monies. Just to give you an idea of what they were selling, these convertible notes, they were generally 1-year notes, convertible after 180 days on certain circumstances, with big penalties, and received at a discount, paying 8 to 12% interest. And once these notes, convertible notes, were agreed upon, the shares, whatever the shares that were involved, had to be set aside by the company. If they needed to be issued, they would have to be issued by the company. So there was a dilution, and the shares kind of were set aside and already in play. So those notes were deemed onerous because the interest rates were substantially lower most of the time that these notes were given. And then they would take the stock, and they got the stock at a discount, et cetera. So it was a entire process that put the company in jeopardy, caused damage to the shareholders because it decreased the share price and further diluted shareholder interest. So that was the scheme. That's what they were found to do, at least 2,000 transactions over that 5-year period of time. In 2013, they did something similar to this, and their name they used at that time, the company was Mazuma. That was the name. So it was Curt with a C and Mazuma. And that was, they agreed before they got into deep proceedings, they agreed to pay back $1.4 million, and they were placed on double secret probation. I guess that didn't work very well, because in 2016, Curt, with a C, ended up with a problem with Hope Capital, again, involving the sale of unregistered shares of Sponge Tech, selling 113 million shares. This time they entered into an agreement. They paid back profit of $525,000, but they got a payment plan, which is entertaining to me in the sense that they stole, apparently they engaged in illicit conduct, generated huge profits, and now they have a payment plan. What happened to the money? Because it's over, as you will see, from 2018 through 2023, which is at the heart of the complaint. It's alleged that they made an approximate profit of $75 million that they know of. So here, a couple of years earlier, they are asking for a payment plan. I find that kind of rich in a way. And my name is Rich, as it turns out. But they agreed, in that case, they also agreed to a cease and desist and a payment plan. They agreed, we're out. So that's 2016. So 2 years later, they're already engaging in the same kind of misconduct, which they did through 2023. Now, why the SEC, after getting these guys twice before, it took them 5 years, 5 years of conduct, but 6 years to go after them, to let them cause further damage to somebody they knew was engaged in misconduct, is indefensible by the SEC. Indefensible. That correlates to the Alpine part, where over 40 years, there's dozens of acts of misconduct that were admitted to or resulted in convictions that the SEC was party to and knew of, but still let them exist. So why is a company like this, and Curt-Kramer and his associates, brothers, sisters, aunts, and uncles, associated companies, whatever LLC he can devise and names that he can devise. And by the way, there's nothing wrong with an LLC. There's a problem with an LLC if it's used like this to engage in illegal or improper transactions. But the question is, after all this, why does it take the SEC another half dozen years and let retail shareholders, who are mostly involved in those microcaps, get harmed? Makes no sense. You have to wonder why. What's the delay? Who's benefiting from that delay? That's the question I have to ask. It really does piss me off, because the conduct was known, just like Alpine. They get a cease and desist. It takes literally thousands of, I think it was, in Alpine's case, 36,000 violations of a cease and desist order, after having committed dozens of other cases of misconduct before the SEC act. And here again, it's, at thousands of acts before the SEC acts. SEC needs to issue the death penalty, put these guys out of their misery. When I mean death penalty, put them out of business. Don't let them operate again. And in the future, as opposed to giving somebody 2 opportunities and then 5 years of violations, it really has to be one. I mean, my suggestion is warning, 1, 2, out. So one warning, then if they do some kind of violation, a substantial penalty and suspension. So it could be, I don't know, disgorgement of the full amount of the transaction itself, not the profit. So if it's a transaction involving $5 million, then they have to pay $5 million plus some civil penalty, plus a suspension of 30 days from doing anything. So first time a warning, 30-day suspension, second time out. Done. Finished. If you can't get it right after the third try and you commit the same kind of misconduct, then you got to be out. So Curt-Kramer, you got to be out. And obviously there was an impact on GTII and probably other securities that are involved with Mr. Kramer, because it involved 350 different tickers. But there's no room for these people in in the financial industry, and the SEC has to be much tougher. And to the extent, like in Alpine, they need to go to court as opposed to let their own internal systems waste time and effort. Because as I have experienced, not all aspects of their judicial systems work perfectly. Anyway, hope that summarizes it for you. So it's ongoing civil action seeks basically to shut down C-Kramer and the entities named, and I hope he will not be permitted to use other entities. And I think it's, again, another step in the right direction, but the SEC has to act much more quickly, and I expect and hope treatment of Alpine is similar. We shall see. I looked at the appellate record this morning. The ruling on Alpine has not come in as of today, May 8th. I will keep on checking, and I'll advise you when it does. And I'll advise you, by the way, what happens with the review of the other expulsion of Alpine. So hope that clarifies things. If you have questions, comments, feel free. Have a great day.